Ever wanted to bounce around an HR issue with a knowledgeable lawyer? Well, now you can. Welcome to We Have This Employee, workplace scenarios from CIE Legal's HR lawyers, where Andrew Marr and Ines chat about their perspective on an HR hot topic.
Welcome to We Have This Employee. Well, we have this employee who is currently engaged under an employment contract with a set-off clause in it. Under that contractual set-off clause, the employer pays an annual salary, and that is intended to compensate the employee for various award entitlements such as penalty rates, overtime, annual leave loading, which wouldn't receive extra payment because they're already covered by the salary. However, as a result of a recent federal court decision, known colloquially as the Woolworths decision, set-off clauses are now under scrutiny, and a majority of them, if not all of them, will not operate as they had been understood to operate by employers. So, Ines, over to you. What is the Woolworths decision all about?
Thanks, Andrew. Yeah, I feel like Woolworths got the short end of the stick there because it's Woolworths and Coles.
Yeah.
But everyone's talking about the Woolworths decision.
Yeah, okay. Well, the duopoly, at least they're sharing the pain.
So the case involved actually 4 separate proceedings, which were essentially heard together. There were 2 enforcement actions by the Fair Work Ombudsman for underpayments of award entitlements, and there were 2 class actions as well brought on behalf of affected employees of Woolies and Coles.
Okay.
And it included your store managers, your section managers, like the dairy manager or the butcher manager. So really the guys that are on the floor in the coalface. And they're covered by the General Retail Industry Award, but were paid annual salaries under individual common law contracts which had set-off clauses. The employees alleged that they were paid annual salaries that were meant to compensate them for all their work, but their actual hours worked and the entitlements they were owed exceeded what they were paid under their salary arrangements.
Right. So even under the old operation, prior to this decision of common law set-off clauses, there's a problem there because a set-off clause, and we'll talk a little bit about what set-off clauses actually are in a sec, but one of the basic prerequisites of successful operation of a contractual set-off clause is that the overall amount paid to the employee as an annualised salary will meet or exceed what they would have been entitled to had the various award entitlements been paid separately.
Yeah, that's right.
So problem number 1.
Yep. So these guys were saying that notwithstanding that they were still not paid enough under their common law contract than what they would have been paid if they were paid in accordance with the award.
What, based on their actual hours worked?
Based on their actual hours worked. And so the benefits that they said they were entitled to were overtime, penalty rates, meal break entitlements, allowances and annual leave loading, which you already mentioned earlier.
Yes.
So both Coles and Woolworths had set-off clauses in their employment contracts. They were a little bit different though. Woolworths specified that the set-off clause worked over a 26-week period. So basically, if you look at a 26-week period, there could be weeks where the employee would earn more than what they would have if they were paid in accordance with the award, and there would be weeks where it would be less.
Yeah, so the theory is over, say, a 6-month period, in the case of those contracts, it would all balance up.
Yep, that's it. Woolworths also paid their managers fortnightly. So, and the pay period is going to be important in a minute. Coles actually didn't give a specific time period. They just said that this is your salary, this is what it's intended to cover.
Right, which is not uncommon for a common law set-off clause. Okay, so I guess for the benefit of everyone, it's worth talking about what a common law set-off clause is. A common law set-off clause is effectively a defence to an award underpayment claim. So what the courts have recognised, and there was a long run of cases, Ecob and Paletti, there was the Giavoni case, and a number of more recent cases that have confirmed that set-off clauses are legally valid and they can operate. But this decision obviously has the potential to very significantly impact on the way that we all understood common law contracts to operate, and common law set-off clauses in particular, bearing in mind that this clause also refers to a very specific provision of the Fair Work Act that didn't exist when these major cases were decided. But a common law set-off clause does effectively what we've just been talking about. It allows you to pay an annualised salary and have that effectively set off against the claim, really, if a claim was made for non-payment of certain award entitlements. And the theory is that as long as the set-off clause stipulates what it is intended to cover and also is sufficient to cover those entitlements when taken together, then that will be a defence to a claim of underpayment. They are so common. Every contract we've drafted contains the common law set-off clause.
Yep.
And they are really only relevant for award-covered employees, really, because the cases, the authorities did establish that there are certain things you can't set off. I mean, you can't set off against annual leave. You can't set off against sort of non-work-based entitlements. I mean, you can set off against allowances and things like that. Things that arise as payment entitlements in the ordinary course of work are the sort of things that a set-off clause can deal with. And that also includes something like annual leave loading, that's loading paid on top of annual leave when you take annual leave. So it's not uncommon at all for annual leave loading to be included in a set-off clause. So the case is established that as long as there is a contractual provision that makes it clear that there is an intention to have that salary set off against award entitlements, then it can be legally operative. Now, it's probably worth mentioning as well that there is, because there is often a little confusion about this, that a number of awards now contain annualised salary provisions that allow an annualised salary to effectively, it's not really a set-off, but to compensate employees for various individual award entitlements, and the awards themselves contain provisions that make sure that a person's no worse off because you'll have to go back and reconcile, usually within a 12-month period, the amounts actually paid to a person in their salary or as part of their salary against the various award entitlements they would have been entitled to based on their pattern of work. But these annualised salary provisions in an award are actually fundamentally different from a common law set-off clause. As I said before, a common law set-off clause is a defence, whereas the annualised salary actually changes the operation of the award. So rather than having to say, well, yes, we haven't paid those various entitlements, but in our defence, we've paid a salary and have a contract in place with a set-off clause that allows us to treat that salary payment as satisfying those various entitlements. The award changes its operation and says you are in fact satisfying those entitlements rather than having to be a defence. They are actually being satisfied by the payment of an annualised salary, provided that annualised salary is administered in accordance with the requirements of the award. So they are two different things, and people do get a little bit confused about them. So now that we know what a common law set-off clause is, back to the case.
Is it worthwhile just quickly mentioning what happens if a contract didn't have a set-off clause, but the annual salary that the person was paid was intended to compensate them for all their award entitlements?
Well, if there is no contractual set-off clause, you've got no right generally of common law set-off because you are not stipulating that salary is intended to compensate a person for those particular award entitlements. And in one of the cases, I think it was Giovoni, there was sort of an understanding that there was sort of an overpayment of award entitlements in terms of the minimum rate in the award that was intended to compensate for overtime, but it was never made explicit in written form. And in that case, from memory, I haven't read it for years, but in that case, I don't think that the court found that there was a right of set-off because it wasn't expressly agreed between the employer and the employee prior to those entitlements being enlivened or being operative.
So then you get the situation where the employer's paid all this money, but then when they're doing the back pay, they have to pay the full amount that's owing to the employee.
Absolutely. And there have been a number of employers who have been horrified to find that they had paid this salary on the assumption that it would be enough to cover the person for their minimum rate under the award and all the various work-based entitlements, monetary entitlements that the award would provide for, and suddenly find, as you said then, that not only do they have to pay this above award salary, but then they have to pay back all these entitlements as well. So if you don't have a written common law sort of set-off clause, you're not even getting to square one.
Yeah. So in terms of going back to the case, the one thing that was discussed was Section 323 of the Fair Work Act, and the Fair Work Ombudsman said that the contractual set-off clauses for Coles and Woolies were unlawful because under that little section, that's the section that talks about how an employer must pay an employee amounts payable to the employee in relation to the performance of work in full, in money, so not in kind.
Not in bananas.
Yeah. Or cars, and at least monthly. So what the Fair Work Ombudsman said was, well, so anything over the award payment could not be distributed across paid periods.
And there's the key.
Yeah.
Or the kicker, as they say.
So let's get to the decision. It was pretty black and white.
Yeah, there's not much wriggle room.
No, there isn't. So basically what was found was...
In fact, sorry to interrupt, but when I say there's not much wriggle room, in fact, the judge said that in their view, sort of no amount of careful drafting would get around this particular problem. So not only is there appear to be no wriggle room based on the judgment itself, but the judge had actually already foreshadowed that it would be very difficult to try and circumvent the implications of this decision with respect to common law set-off clauses.
Yeah, so to write your way out of it.
Yeah. Yes, difficult to write your way out of it, at least based on what the judge's commentary was, and actually the decision itself, which, as you said, is pretty black and white.
Yeah. So basically, that key element of within a pay period meant that any set-off that a contractual set-off clause was supposed to do could not occur throughout pay periods or
across multiple pay periods.
Yeah,
across multiple pay periods.
It could not occur across multiple pay periods. So as he said, yeah, look, a well-drafted contractual set-off clause could work within a pay period.
Yeah, and the problem, of course, is that the longest pay period that I'm aware of is a month, and there are a number of businesses that will be either weekly or fortnightly. Now, if it's weekly, the set-off clause virtually becomes meaningless. I mean, you're not getting any capacity to set off. I mean, even awards, though they might have averaging provisions that allow you to work ordinary hours over a month, and I don't know if the decision really turned its mind to that, because that does become a little bit more complicated when you are allowed, your ordinary hours don't necessarily, you might work 40 hours in 1 week, and if the award allows for averaging over, say, it was 152 hours, then that overtime doesn't really become overtime until you have worked, say, 38 hours at least in those other, say this is the first week, in those other 3 weeks. Because if you work 36 hours next week, well, then all of a sudden those 2 hours in the first week are not overtime because they're actually part of the ordinary hours because it's been averaged out. Now, I don't even know how that's going to sit with the decision, but highly problematic for businesses where they are paying people either weekly or fortnightly, but it's also highly problematic for businesses that are paying monthly. I guess the one thing I would say about set-offs is you generally see them more often than not with more sort of, white-collar executive, more senior sort of roles. And those roles perhaps are more likely to be paid, say, monthly. I mean, obviously not invariably, but they might be more likely to be paid monthly under existing arrangements, whereas you might find, say, a blue-collar worker working on the factory floor may actually be on a weekly pay cycle, but most employers are probably not using a common law set-off clause to deal with payment to those employees, but will be using them for those sort of salaried staff, as often people call them, which are more likely to be more senior managerial, white-collar. So perhaps that's a tiny bit of a silver lining. I mean, it's not silver, it's like dull grey, but it is something that may give the slightest amount of comfort that those sort of employment types where common law contracts do have common law set-off clauses and the employers are relying on them may also have in them a longer pay period. But even over a month, you're not really getting much wriggle room, are you?
No. And look, I made the point of mentioning that Woolworths paid these managers fortnightly, right? So that meant really moving forward, every fortnight, so as not to fall foul of modern award obligations, if there is an underpayment under the award, the employee would need to be compensated and paid the additional amount so they equal the minimum award entitlements for that fortnight. And
even though in the following month they might be being paid, if not significantly above the award, something above the award. So they basically get to have their cake and eat it too.
Yep. And really, for contracts moving forward, it's not going to be your base salary will be X per annum. It'll be your minimum annual salary will be X, because for those fortnights or months where the employee would have earned less under the modern award, so they're better off under the employment contract, you can't minus that. Well, no, because you have a contractual obligation to pay that amount for that pay period.
Yeah, that's right. So in this situation, it is effectively a minimum salary. I mean, it might be your base annual salary is $120,000 a year, with the recognition that you're going to have to do a reconciliation within every pay period.
Yep.
Now, obviously, that becomes very complicated when you are doing weekly pay periods. A reconciliation every week is very difficult. So in that situation, I would imagine most employers will go back just to a pure award payment type situation, whereas the person might be getting a rate, a sort of a minimum rate that's above the award, but they will be using a very clear, okay, you've worked overtime, you get time and a half, double time or whatever it's going to be for those particular hours worked, and they're going to move back to a very strict implementation of the award, albeit bearing in mind that they may have a sort of a market rate that's paid above the award minimum, but they will need to go back to a fairly doctrinaire approach to award implementation.
Yeah, and we'll definitely pick that apart a bit more as to what as an employer, what can you do? Because you're probably sitting there listening going, oh my God. The other part of the decision, which is still worthwhile mentioning, is around record keeping obligations.
Well, I think it's critical to mention it because it's the flip side of it, and it really does put a significant focus on an employer's record-keeping obligations under the Fair Work Act and the Fair Work regulations.
So with these salaried managers, because they were salaried, right, there was no strict way to record their time because they have clock-ins, so they had informal clock-in records, and they had rosters. But rosters doesn't necessarily turn into hours worked, though. That's not what it means, and that's what was found because Woolworths and Coles said, well, hold on, no, we've got these rosters and we've got these clock-in records, so yeah, we have met our obligation. It was found that, no, it's not sufficient. And actually...
No, because you've got to record overtime on pay slips and you've got to record these separate award entitlements as part of your record-keeping obligations. I mean, they were lucky in a sense that they did have clock-in and roster records because a lot of employers who have employees on salaries are not going to have clock-ins, and they're probably going to have no record of genuine hours worked. Arguably a breach of the obligations under the Act, even prior to this decision, sort of putting the spotlight on it. But it becomes really pressing for employers to make sure that they're doing that, because otherwise there's going to be no capacity to reconcile within a pay period.
Yep, that's exactly right. So, well, what does this mean for employers? Well, like you already said, if you have award-covered employees on annual salaries governed by a common law set-off clause, then you can't ignore this. You do need to take action.
No, you certainly can't.
First of all, you need to identify how you're actually going to track employees' working hours moving forward. And
yes.
A big one for me that I think of is the administrative staff. Because, generally
who
they
are going to be invariably award covered,
Yep.
whether it's, the Clerk's Private Sector Award or another award that actually has admin classifications in it in a particular industry, but they are going to be award covered and they are not infrequently on salaries.
And another thing to do as an employer is to speak to your payroll department or your payroll provider. You need to set up a reconciliation process for your salaried staff.
Yeah.
So you need to talk to your payroll provider, see if they can put in all these different modern award entitlements and the appropriate dollar values of these tied to each employee. So you can actually reconcile and you're reconciling accurately. And if it's been a while since you've had a modern award review done and double-checked your classifications of your employees, you probably want to do that too, because you don't want to set this all up and you're using the wrong classification level, which will invariably mean that you're using the wrong base rate which will just lead to, I kind of want to say disaster.
Well, I don't know if that's necessarily overstating it. It is a major wake-up call for employers, something that, even as legal advisors, we have encouraged the use of and said that they could be relied upon. It is really going to be a major change. And so, I hate to be, and you hate to be, the bearer of bad tidings if this is the first time any of the listeners have heard about this. But it is certainly something that needs attention if employers are using common law set-off clauses at present and are not reconciling within a pay period, which most of them won't be doing.
Another thing is see if you can change your pay period with consultation. So have a look.
Push it out to a month if you can.
Yeah, taking into consideration any potential restrictions in the relevant modern award, because I think some of them have restrictions up to fortnight or something.
Yeah, that's right.
And review your set-off clauses. They're not dead, so you can still use them to set off obligations within a pay period. So just make sure that they are appropriately drafted and get them reviewed.
Absolutely. Thank you, Ines.
Thank you.
Thanks for joining us on We Have This Employee. If you like what you've heard, please subscribe, leave a review, and share this episode with your colleagues. You can find this podcast and all episodes in the series on our website, www.cielegal.com.au, on LinkedIn, and all the usual podcast hosting platforms. Until next time, thanks for listening.